Good afternoon, and welcome to McGuireWoods annual U.S. Supreme Court term preview for October term 2024. We're delighted you've joined us this afternoon, and we're looking forward to a great discussion. We'll start with a few introductions. My name is Jonathan Ellis. I serve as a co-chair of the firm's Appeals and Issues practice. I split my time between our Raleigh and our D.C. offices. And as relevant here, I clerked for the Chief Justice Roberts, during October term 2012. I'm joined today by an excellent group of my partners to discuss the court in this upcoming term. I'll try to mostly stay out of the way. Let me start with some introductions of our panel here. Katie Barber is joined us from the Richmond office. She's my co-chair of the Appeals and Issues practice. She clerked for Justice Ginsburg in October term 2018. John Moran is a partner in the firm's Government Investigations and White Collar practice. He sits in our D.C. office. John clerked for Justice Scalia in October term 2011. And finally, Michael Scoville is a recent addition to McGuireWoods. He joined us just in June 2024. He clerked for Justice Kennedy in October term 2004. He served as a federal prosecutor and now is a co-chair of our firm's defense and aerospace industry team. As we typically do with our preview each year, we'll start the conversation with just a quick look back at last term, talk a little bit about the stats and the big cases that were decided briefly, and what we can glean from another year at the court. Then we'll turn our focus to this term that just began and preview for you some of the big cases or biggest cases that the court has docketed so far, some of which it's already heard argument in this week. Just as a reminder and some housekeeping, if you submitted your state bar information with your registration, we'll submit that for CLE credit to your respective bars. And we welcome questions during this presentation. We will, as always, aspire to leave some room at the end for questions. I predict we will, as always, run out of time before we get to that slide. So please, as we go along, submit your questions. There should be a tab on your browser, and we'll keep an eye on those and address those when we can. Finally, if you have any technical difficulties, please submit those as well. And we have some folks monitoring who will help you with those problems if any arise. So with that, let's turn to the preview and start with a review. October term 23 wrapped up at the beginning of July of this year. The court last term issued 59 decisions in cases that were after oral argument. Of those 59 decisions, 27 were unanimously decided, 22 were decided by a 6-3 vote, and the rest were decided by some combination in between. The court had enjoyed a typical level of unanimity. 46% of the cases that were decided, as I said, a 9-0 vote. It's the same, almost exactly the same as October term 2022, and actually a little bit higher than the rates of unanimity in the last several terms. Similarly, the court splitting the 63 decisions were similar statistics to previous terms. Although I note that although there are 22 6-3 decisions, only half of those were decided along the ideological split you might imagine. The other 11 were decided with some combination of justices who were appointed by Republican or Democratic presidents. And there were really some meaningful ones in that bunch. The Fisher case, which was a case concerning one of the prosecutions of the January 6th rioters, was decided on a 6-3 vote, but Justice Jackson was in the majority, calling into question one of the claims in that case, and Justice Barrett was in dissent in that case. The court continued to have a rather slow pace of decisions again last term, as it has in recent terms, deciding most of its cases and certainly most of the big cases right there at the end of the term. And as I noted at the top, the term didn't actually end, or the court didn't actually issue its last decision until the beginning of July, putting aside a couple years, COVID years. That's the first time that's happened since 1995, October term 1995. So that's enough for me. Why don't we pull in the rest of the panelists and get some views here? And the first question, I'll open it up to the floor, is why the court's granting so few cases. 59, as I said, from last year is historic lows. What explains the court's reticence to resolve more cases?
Yeah, so I'm happy to provide some thoughts there. I think there are a couple different dynamics that are going on. One, I think there's, every time you have a recomposition of the court, we have, and we've had over the last several years, new justices adding. There's kind of a reshuffling of how they view which cases they want to take. The most traditional criteria being, cases where there's a circuit split or a split among, the highest courts of various states. I don't know that there's a material difference in, the types of cases that meet those criteria, but underneath those criteria, every justice has kind of their own ideas of which types of cases they should take. And in particular, I think there are some justices who are, more, I guess by contrast, I'll take my old boss, Justice Scalia, who I think kind of generally had the view of, hey, if there's a circuit split, win or lose, if I think my side's going to prevail or not, we should just go ahead and take the case and resolve it and let the chips fall where they may. I think some other justices, are a little bit more strategic in their thinking about what cases they want to vote to grant. I also think the flip side of that, and probably in many ways the even bigger driver, is that litigants are very strategic about which cases they want to bring to the court. And I think there are, every year, this is always true, that there are cases that would be very good candidates for cert because they present a clear circuit split, and it's indisputable that, if this case had been decided in a different circuit, it would have come out another way. But the litigants make a strategic decision of, is this really the right time or the right case to bring this issue before the Supreme Court? And, a classic example is the criminal defense bar or the immigration bar, where, their clients might be on the losing side of an issue, but they're not so sure that a majority of the Supreme Court is going to agree with them. And so they basically decide not to pursue cert and say, well, it's better that a few circuits have a good rule than that no circuits have a good rule. So I think there's a lot of different factors that go into it, but it certainly is, a longstanding trend and a continuing trend of decline.
That's all fair, John. I think to that last point, and maybe to both your points there, I think maybe the litigants who think the 6-3 court's not going to go their way are pulling back. But I guess on the flip side of that, you'd think with a pretty clear majority of Republican-appointed justices, you'd have some folks who are willing to take up cases that they might not have before. And if you've got a justice who is thinking strategically about how they're voting to grant cert, you got 5 other justices who think your way, tend to think your way, and you only need to have 4 votes to grant cert. You'd think there would be an uptick in grants, at least in cases that are likely to split on ideological lines or likely to appeal to the right side of the bench. Katie, any thoughts on why we're not seeing that play out?
Well, I think maybe because it takes 4 votes to grant cert, but it takes 5 to have a majority in a case, right? And I do think you see, even among the Republican-appointed justices, you see some divisions of just how they are approaching different issues and thinking about different cases. I think you see it there's a lot of separate opinion writing, fractured reasoning that's happening in some of these cases. And so I think there may be a hesitancy among some of the justices because they just don't know, you may all agree that a case is cert worthy, but it's not entirely clear at that stage how it's going to shake out on the merits. And you have seen, a tendency of some of these justices to kind of go in different directions, even if, facially they might seem like they would kind of align on the same side. It doesn't always actually shake out that way when they actually decide the case.
Fair enough. Well, let's move on then and take a look at oral arguments. The court maintained in this last term its recent format for oral argument, allotting each side 30 minutes of time generally to present their arguments, but then following up on that 30 minutes of time with an opportunity for each justice to ask questions, sort of seriatim questioning in reverse order of seniority. I think what we saw last term, and we have seen the last few terms, is that can lead to some rather long arguments at the court. Arguments frequently exceeded an hour last year, and sometimes 2 hours. The longest argument came in the presidential immunity case, Trump v. United States, which clocked in at 2 hours and 40 minutes of argument time. We've got a chart here showing how that argument time broke down. The chart on the left is the word count per justice, and the chart on the right is minutes spoken per justice. I think what is hard to miss in these slides is that Justice Jackson continues to dominate much of the argument time, both in words spoken and in time spoken. And Justice Kagan and Justice Sotomayor are not far behind, nor is Justice Gorsuch in the time that they're using to question the justices or perhaps to speak to their colleagues. So, Michael, you have any views on what explains that phenomenon?
Well, the first thing that I was trying to do here is compute whether we can infer from the chart who speaks the quickest of all the Supreme Court justices. And I think it looks like that math works out as being it might be Justice Gorsuch who's in the lead there for the highest word pace per minute. But, you know, it's been 20 years since I clerked at the court, and the Rehnquist court, which mine was the last year of that court, definitely had a lot less argument time and I think less participation. I think this is a welcome development. I think it's healthy for people to see the justices participating actively in the argument and for all of the justices to be participating, as we can see reflected in this slide.
Kitty, would you think Justice Jackson in her time is speaking more to the court, or is she using some of that time to sort of speak to the public, her fellow justices? How do you think about the division?
I think it's probably more that she's speaking to her fellow justices, but I think she probably is also speaking somewhat to the public. But I think if you look at it from the perspective that this was her second term on the court, so she is still the most junior, newest justice. That means when they discuss cases at conference, she is the last justice to speak because they speak conference in order of seniority. And conference also happens after arguments. So this is kind of one of the first opportunities that she's having to kind of get her views out in front of her colleagues. And I think, you know, that's not unique to her. The justices generally, I think, are often kind of speaking more to each other than they may be to even the litigants or the public when they're asking these questions. And they're kind of, I think you see that with Justice Jackson, that you can kind of read into what she's usually making, you don't even have to read into it. She's usually making pretty clear kind of what she thinks about a case and how she's approaching it. And so she's really just up there kind of giving her perspective on things. And I think it's mostly geared towards her colleagues. But I don't think she's, unaware that she's also, there are snippets of what she says on the bench getting picked up kind of in coverage of these cases too, and that the public is getting that insight as well.
Well, let's turn now to the way that the justices most formally speak to the public, and of course that's in their decisions. This will be the last sort of statistics we cover on last term before we turn to previewing this coming term. But I think it's worth looking at again the sort of breakdown, the vote breakdown of the cases that were decided last year. And I think what you see is that once again, that the Chief Justice, Justice Barrett, and Justice Kavanaugh find themselves in the majority most often as compared to their fellow justices. That has been the case ever since Justice Barrett joined the court. And beyond that, the Chief Justice and Justice Kavanaugh sort of are really, those two are the ones that are in majority most frequently. This term, it looks like the Chief Justice was in the majority, something like 96, 97% of the time. Justice Kavanaugh, 95. That's a slight switch. I think the last 2 years, Justice Kavanaugh has been on the majority the most, but obviously not much of a difference there. I think one thing to notice when you're looking at the statistics beyond those three is that last term, Justice Alito and Justice Thomas found themselves in the majority, the least of any justice, of the two justices on the court. That's changed this term, and it now looks this past term that the democratically appointed justices were in the dissent most frequently among all the justices. So here I'll ask the group. There's been these discussions over the last year or two about this 3-3-3 court, and I think these statistically give some support to that notion. As I say, those three on the screen there have been the majority, the most frequently for the entire time that we've had this court. John, what do you think? Do you think it is a 3-3 court and 3-3-3 court, and if so, along what lines?
Yeah, so I think there's some value in thinking. I don't think it's a perfect description. I don't think it captures, obviously all the nuance. I think, it is helpful though to think of kind of three blocks of the court, to think of, the Democratic appointees, Kagan, Sotomayor, and Jackson as sort of one unit of the court, to think of Thomas, Alito, and Gorsuch as, probably the most predictably conservative group in the court, and then Roberts, Kavanaugh, and Barrett in the middle. I think to the extent there's reason to resist that label or that grouping, it's just because it's not quite that simple. It's not as if those are, especially that middle block, as if it's kind of a monolithic block or takes the same approach. If anything, I think what you see is among the 6 Republican appointed justices, two somewhat different thoughts that are not so much about the substance of any particular case, but maybe a little bit more of a different approach to the court's work. And I think it's fair to think about Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett as institutionalists who kind of have a very keen eye towards the Supreme Court as an institution, about the limits of its role, what its proper role is. What types of cases it should be getting involved in, and when it should be speaking versus not speaking. Whereas, again, this is painting with a broad brush, but Justices Thomas and Alito and Gorsuch, might be less concerned about that, more willing to say, hey, let's take the case. Here's my view of how it should come out, and I'm not going to be as concerned about how that might fit into kind of a bigger picture of the court as an institution. So, again, that's not a perfect way to think about the court, and it obviously, a lot of these cases break down, in different ways. But I do think it's a useful framework to have in mind when you're thinking about big cases and the court as a whole.
I think the other stream that's been going around, I think even New York Times wrote about it, is this idea that that the Justice Barrett might have an independent streak. Certainly, I think there's some support for that. She dissented in part from the court's decision in Anderson v. Colorado about the Trump's ballot access. She dissented in part from the court's presidential immunity decision concerning Trump. She wrote separately in Rahimi, and she dissented in a big administrative law case concerning the EPA's Good Neighbor Rule, in a case called Ohio v. EPA, writing the dissent on behalf of her and the 3 Democratically appointed justices. Katie, what do you think about that idea? Do you think that Justice Barrett is really is kind of staking out a different path than some of her colleagues, or is that maybe a little premature?
I think it's probably a little premature and or a little overblown. I think she's now in her third. This was her third term. I think she has been slower than Justice Jackson to kind of come out and kind of make her own voice heard a little more. And so I think that's maybe what you were seeing this term, is that she was kind of maybe gaining a little more of her footing in terms of kind of, writing separately or staking out some of these different positions. I would say, though, that I see her as more of a centralizing figure than really kind of an independent, gonna kind of go her own way. I think she, as you see with her frequency in the majority, I think she seems to kind of more have the tendency that the chief has and that Justice Kavanaugh sometimes have of kind of trying to seek a little bit of like consensus or move a little bit more to the center, take more of kind of a gradual approach to cases, maybe a more cautious approach than maybe some of the other Republican appointed justices are inclined to do. So I think, I'm not sure that this kind of shows that she's going to be joining with the Democratic appointed justices in all these cases or anything like that. I think she clearly has her principles and is deciding cases according to those, but I don't think that means she's going to kind of be this newly independent figure going forward.
All right, well, let's keep going and get to some of the previews. Just a quick reminder about what was on the docket substantively last term. It was a big one. There were cases in administrative law. Loper-Bright overturned the Chevron doctrine, constraining federal agencies' authority to interpret their organic statutes. Jarchese cut back on agencies' authorities to adjudicate claims before their own agency adjudicators. The court decided 3 different cases concerning former President Trump, which we've already talked about 2 of those, the third, a trademark case. And the court issued another major decision on the Second Amendment. So it was a big term, even though they managed to avoid issuing 2 different decisions with regard to abortion rights. And so let's turn to this case to see this coming term. Is it going to look like the same, or maybe we'll have a bit of a pause? So get everybody's views on that. The court, October 24th term started this week. Started on the first Monday of October, as always. The court has granted so far 43 cases to hear this term, and it has scheduled 16 of those for argument in October and November. It heard 5 cases this week and has several set to be heard next week. I think the meaningful one, it's safe to say that at this point, the October term 24 doesn't have the same, at least volume of sort of fundamental cases going to the structure of our government, or really as many sort of hot button top cultural issues on the docket. But we've got 43 cases granted so far. There's still room to grant more. And I think what can't be lost is that we're in an election year. Almost certainly we're going to have some more cases involving and probably some activity on the emergency docket, or shadow docket as it's sometimes called, concerning those sort of emergency issues on the election. So we will see what comes. But in the meantime, let's talk about what we have on the docket already. And we're going to start with John Moran and a case called Garland v. Vanderstock concerning what the administration at least calls ghost guns.
Jonathan. So Vanderstock was actually argued on Tuesday, one of the first cases of the term. Obviously, we don't have a decision yet, but it's one that people will definitely watch and hear about when the decision is handed down. So this arises under the Gun Control Act of 1968, which provides for the federal regulation of firearms. And it defines firearms as, quote, any weapon which will or is designed to or may be readily converted to expel a projectile by an action of an explosive. And then it also separately provides that, quote, the frame or receiver of any such weapon, end quote, can be regulated as a firearm. And so the question here is about so-called ghost guns, as Jonathan said. One of the key features of the Gun Control Act is that covered firearms need to have a printed serial number. And as a general matter, they need to be sold or exchanged through a federal firearm licensee, also commonly referred to as an FFL. And that's the primary way that the Bureau of Alcohol, Tobacco, and Firearms and Explosives, ATF, tracks firearms in criminal investigations and supports state and local law enforcement in doing the same thing. And so when you have a kit of parts, or you have, something that can very easily be turned into a firearm, but it isn't treated as a firearm, then it can, you have the ability for people to create firearms without having a serial number, without having that kind of traceability through the FFL system. And that's where the name Ghost Guns comes from. So the case arises out of a 2022 regulation issued by ATF and the DOJ, which basically took a two-prong attack to try to bring at least many of these devices or kits within the scope of federal regulation under the Gun Control Act, both by saying essentially that a kit that's readily convertible into a firearm with sort of basic tooling at home, you might need a drill or a screwdriver, but you don't need, heavy manufacturing machinery, that can be regulated as a firearm. And also essentially saying that a frame or receiver, if it's readily convertible into a frame or receiver, a piece, if it's readily convertible into a frame or receiver, is also covered. This had not, there's a lot of debate in the case about the extent to which this is consistent with ATF's traditional interpretation of the Gun Control Act, but obviously ATF made the decision to go out and promulgate a new regulation. And the question in the case is that regulation within the scope of ATF and DOJ's authority under the Gun Control Act, or does it go beyond what the act authorizes them to regulate? The case takes on sort of a new valence after Loper Bright and after the court overturned the Chevron doctrine. So it's clear that the court is not going to be giving Chevron deference to the agency's interpretation of the act, but instead is going to be essentially deciding for itself under the best reading of the statute whether this is permissible. And in that regard, this case could be an early indication of what the post-Chevron world looks like. Another interesting aspect of this case is that it does not come to the court for the first time. This came up last year on an injunction that had been issued by District Judge Reed O'Connor in the Northern District of Texas, enjoining the Biden administration from enforcing this rule. That decision was ultimately affirmed by the Fifth Circuit, but in the meantime, the Supreme Court granted the United States a stay of the injunction and essentially allowed the regulation to go into effect while the case was pending. That was a 5-4 decision that was Justices Kagan, Sotomayor, and Jackson, joined by Chief Justice Roberts and Justice Barrett. And so, we will obviously see how the case comes out now that it's been argued on the merits. Probably the easiest betting money is that it will be affirmed on that, or reversed, I guess, the Fifth Circuit, but the prior stay decision, reinforced by the same 5-4 majority. But as you can readily tell, that means that, it represents another potential split among the Republican appointed justices on a question of statutory interpretation that also, happens to involve a firearm question, even though it doesn't directly implicate the Second Amendment.
Yeah, I was going to ask about that. I think that's the second straight term now that we've had a statutory case concerning firearm regulations. Last term, there was, of course, the Rahimi case on the Second Amendment, but there was also the bump stock case about Cargill, about the regulation of bump stocks. Maybe I'll ask Michael, pull him into this conversation here. Do you think that the Second Amendment and the justices' views on the Second Amendment have anything to do with how they approach these statutory cases?
I think with this one, this is probably going to be resolved on the statutory grounds rather than by virtue of some sort of constitutional avoidance doctrine. I think this falls within the Heller distinction for conditions and qualifications on commercial sale of arms. I think that's what we're talking about. We're not talking about whether someone with a gunsmithing lathe at home has a constitutional right to craft their own musket. This is about essentially the IKEA version of a firearm that you can, put together at home in about 15 minutes, which I think, by the way, Solicitor General Preligar at the argument said she'd actually done, which I found kind of amusing.
Yeah, I caught that. John, what did we learn from the oral argument?
Well, we didn't learn a whole lot other than there doesn't seem a lot of reason to think that that the voting lineup is going to change. And so I think, again, my betting money is on sort of the 5-4 majority that voted to stay the injunction being a same 5-4 majority that votes to uphold the regulation at the end of the day.
All right. Well, with that, let's turn to the next case on our docket, Glossop v. Oklahoma. Michael, you want to tell us what this case is about?
Absolutely. Thank you. So this is a capital case that was just argued yesterday. The crime at issue was a murder committed in 1997 at a hotel in Oklahoma. The victim was bludgeoned to death with a baseball bat by a man who worked as a handyman at the hotel. And the state's theory at trial was that Glossop, the manager of the hotel, had paid the handyman $10,000 to commit the murder. And of course, that handyman was a key witness against Glossop at the trial. He'd made a deal with the state to testify in exchange for a promise that Oklahoma would not seek the death penalty against him. This case has been to the Supreme Court before. This is actually, I think, the 5th post-conviction relief petition filed by Mr. Glossop. In 2015, the Glossop versus Gross case was decided. That involved a challenge to Oklahoma's lethal injection protocol, which the Supreme Court rejected. But the legal challenges nonetheless continued. And this time, the issue that Mr. Glossop is raising involves a claim that prosecutors at his trial suppressed evidence that the handyman, who again testified against Glossop and was a key witness for the prosecution, was taking lithium that had been prescribed by a psychiatrist. The jury knew that he was taking lithium, but on cross-examination, the handyman had said that he was given lithium by some other doctor for a cold rather than by a psychiatrist. And the state's arguing that Mr. Glossop, actually joined by the Oklahoma Attorney General, which has confessed error and is also seeking to get the conviction thrown out and to have Mr. Glossop a new trial. They are all arguing that this was a fundamental violation of due process under Brady and Napiew, and that Mr. Glossop's conviction should be overturned. Now, the Oklahoma Court of Criminal Appeals rejected Mr. Glossop's argument and held as a matter of Oklahoma post-conviction procedure that Mr. Glossop was barred from raising it because he didn't do so with reasonable diligence. When the Supreme Court granted review, it appointed special amicus counsel, Christopher Michel, a former clerk for the Chief Justice, to defend the judgment below because the state had abandoned it and was seeking to have the conviction overturned. The Supreme Court also directed the parties to brief whether the state post-conviction procedure issue presented an adequate and independent state law ground justifying the Oklahoma court's decision. With respect to that issue, interestingly enough, the Oklahoma Attorney General has argued that he has the power to waive that post-conviction relief procedure and that he's sought to do so, but that the Oklahoma Court of Criminal Appeals rejected the waiver. So there's a lot of procedural background here. And one final thing to note is that Justice Gorsuch has recused himself, which creates the possibility of a 4-4 split that would leave the Oklahoma court opinion in place. So, based on oral argument yesterday, I think there's definitely 3 votes to reverse. Justices Kagan, Jackson, and Sotomayor all asked questions suggesting they had no issue with the procedural bar issue. They would reach the merits, and they were disturbed by the conduct at issue. So I think you've got 3 votes for Mr. Glossop there. But I think it's unclear where the 4th or 5th votes to reverse might come from. In particular, both Justice Alito and Chief Justice Roberts asked questions suggesting that even if they were to reach the merits, they would have difficulty with the notion that it would have made a difference in the trial to know that a psychiatrist had prescribed lithium to the handyman as opposed to some other healthcare provider.
Michael, we've got a question from the audience about the source of Gorsuch's recusal. Do you know what caused him to recuse here?
I believe the answer is that in one of the previous go-rounds of Mr. Glossop's post-conviction relief appeals, it came up to the 10th Circuit when Justice Gorsuch was there.
That makes sense. Katie, I think you listened to oral argument yesterday. Do you have a different take or something to add to Michael's description?
No, I think that's all right. I mean, it was a fascinating argument to listen to. You had a lot of legal star power there. You had Seth Waxman arguing for the petitioners. You had Paul Clement arguing for the state, which are the respondents. And you had a lot of discussion about the adequate and independent state grounds issue and just the procedural issues. And a lot of it seemed to come down to, for some of the justices, some difficulty with just parsing the Oklahoma court's opinion. There was one kind of funny moment where Justice Kagan basically was giving her legal writing critique of how confusingly and badly written the opinion was, because a lot of them were just struggling to figure out whether the court had accepted, had actually invoked this procedural bar, or whether they had accepted the state's waiver. And so that was kind of an interesting aspect of it that I do think that seemed to be kind of a central struggle for a lot of the justices. And so it is kind of unclear where some of them are going to come out on that. I mean, it was, as Michael said, it was very clear where Justices Sotomayor and others were on that point, but I could see some separate writings and fractured reasoning in this decision, and especially when you've got this 8-member court deciding it.
So I think it's somewhat unusual for the court to add questions to a case, right? Usually the way you think about it is that a litigant comes to the court and presents a question that the court decides whether or not to grant. Michael, what do you make of the added question? Can you give our audience any insight into how that might have come about, and how much of a tell that is to where the court's how the court's thinking about this case?
I mean, I think the court takes post-conviction procedural bars very seriously. You see that in lots of the cases that the court has decided over the past few decades. And so I do think it is a tell that at least some of the justices on the court thought that was an issue that needed to be briefed and argued in addition to the merits questions of Brady and Naphew and the alleged due process violation regarding the testimony about who prescribed the lithium. And I think this is probably headed towards a 4-4 split. That would be my prediction on that issue of whether it was an adequate and independent state law ground.
Okay. Well, moving on to a very different topic. Katie, you want to tell us what's going on in Free Speech Coalition v. Paxson?
Sure. So this case is kind of the latest in a series of cases the court has taken up in the last few terms, where they kind of involve the intersection of free speech and the First Amendment with the internet and different government activity or regulation of the internet. So this case arises out of a Texas statute that was enacted, and it requires every commercial entity that publishes or distributes material on a website, more than 1/3 of which is harmful to minors, to put in place age verification measures that ensure all visitors to the website are 18 or over. The law also requires that these websites publish certain disclosures and content warnings. So you had the plaintiffs in the case were various adult filmmakers and related associations. They sought a preliminary and received a preliminary injunction from a district court barring both provisions. The Fifth Circuit on appeal then kept the preliminary injunction in place as to the content warnings provision, but it vacated it as to the age verification requirements. And it did that because it held that the law was subject only to rational basis review, and it relied on a Supreme Court case called Ginsburg to reach that conclusion. Ginsburg was a case where it was about minors' right to access pornographic materials. And in that case, there was no real First Amendment right or interest of these minors to access those materials. The law was thus subject only to rational basis review. But there is this other Supreme Court case called Ashcroft that involved a very similar statute to the Texas law. It was the Child Online Protection Act, and in Ashcroft, the Supreme Court subjected that law to strict scrutiny because it was viewed as a content-based regulation of adults' First Amendment rights. or a content-based restriction on adults' exercise of their First Amendment rights to access and view these types of materials. And so strict scrutiny, of course, means that a law has to be narrowly tailored to serve a compelling state interest, whereas rational basis review is basically, is there a legitimate government interest that this serves? Then, okay, it's kind of checkmark review to some extent. So the petitioners here, in bringing it to the Supreme Court, argue that the Fifth Circuit erred by reviewing this law under rational basis review instead of strict scrutiny. And I think that argument seems pretty correct to me. You have some pretty on-point Supreme Court precedent here. I think the more interesting part of this case, so I mean, and the fact that the Fifth Circuit came out the other way, I think is more reflective of just the fact that the Fifth Circuit has been kind of taken more extreme positions in a lot of similar cases over the last few years. And so this is another case where that seems to have happened. I think the more interesting part of this case is probably going to be not so much in this debate over strict scrutiny and rational basis review, but more in a discussion over whether this law is narrowly tailored to what everyone agrees is a compelling state interest. I mean, there doesn't seem to be any dispute that protecting minors from harmful content is a compelling state interest, but there is more discussion about whether this law is narrowly tailored or not. The United States, the Solicitor General, has weighed in on the side of the petitioners, asking for reversal, but the SG's argument is that the court should not decide whether the law is narrowly tailored or not, and that it should remand for the Fifth Circuit to do that in the first instance, whereas the petitioners argue that the law is not narrowly tailored and make a lot of arguments that I think they hope the court will reach. So to me, that's kind of where maybe the real interesting activity in this case will be, but curious as to my colleagues' thoughts on that.
Yeah, so John, I'd love to hear your thoughts here. I mean, I think it's kind of striking to me that we've had, last term ended with several different justices sort of expressing views that the tiers of scrutiny are not all that helpful at all in these constitutional cases. And yet here we have a case that seems to turn on exactly which tier of scrutiny we should apply. What do you make of that comparison and contrast?
Yeah, I mean, we could end up getting some further clarity on that. I also think, this is an area, interestingly, as the court has been more focused on, grounding more and more of its constitutional rulings in original public meaning. I mean, the First Amendment sort of in general, and then certainly this area of pornography is just not an area where any of it is really tethered to that, and they've never looked to it, at least so far. So I think there's a lot of different ways that this kind of cuts against the trends of what the court has been doing more recently in constitutional cases generally, and in the First Amendment more particularly. So I'd be very interested to see how they sort through that, and whether they kind of try to give a back to basics message through their decision here, or whether they really just stay narrowly focused on the issues of this case.
Katie, you have a prediction on how this one's going to come out?
I mean, I think the Fifth Circuit gets reversed, but beyond that, I'm not entirely sure. I think you could see, maybe to John's point, when certain members of the court especially have been kind of approaching these cases differently, and it's not clear how they're all going to be thinking about this. Even if we think the Fifth Circuit's wrong, how do they all reach that conclusion, and how far do they want to go, I think is more of the question. I think you could end up seeing something like we did with the Moody Net Choice case last term, where everybody agreed that the Fifth Circuit that the lower courts, Fifth and 11th Circuit, had misapplied the facial analysis challenge there. But some of the justices wanted to go further and kind of get into the merits and say, and also the Fifth Circuit, you actually did things wrong on the merits too, beyond that. So I think you might see something like that, especially in kind of a contentious area like this.
Well, let's move on to another area of contention. John, why don't you give us an overview of United States v. Spermetti?
Absolutely. So this case arises from two state laws in Kentucky and Tennessee that prohibit gender-affirming care or sex transition treatments for minors who have gender dysphoria or identify as a different gender, with some limited exceptions. And it's obviously an issue that is widely discussed and debated on the national stage. States have taken very different approaches. And part of what makes this an interesting case is that this is one where the United States, through the Biden administration's Justice Department, has stepped in and sued the states, challenging their laws. As it comes to the Supreme Court, the only issue presented in the case is whether these state laws violate the Equal Protection Clause. The decision below held that from the Sixth Circuit, written by my old boss, Chief Judge Jeff Sutton, the Sixth Circuit's decision said, no, these state laws do not violate the Equal Protection Clause, and sort of outlined three three key points at the front of the opinion, which is very much in line with Judge Sutton's thinking about these cases. He's written books about state constitutional law and state law under the federal Constitution. And he emphasized three things. He said, first, there's no real argument here that the original public meaning of the Equal Protection Clause prohibits these state laws. And so this is not really a case about, mining the historical evidence and trying to figure out, what people understood the Equal Protection Clause to mean at the time it was adopted. Number two, the case is based on prior precedents, but none of those prior precedents squarely addresses the issue presented in these cases. Now, I'll talk a little bit in a minute about, the arguments that they do, but that was his second point. And then the third, and this is really where, it just kind of made me chuckle because this is right up his alley, is, this is an issue that's actively being legislated on, debated, addressed among the several states, and where the law is continuing to develop. And, cited that as a reason why the federal court should be particularly reluctant to step in and say, no, actually, the Equal Protection Clause provides a one-size-fits-all solution to this question. So the particular posture in which this comes up is that the United States sought a preliminary injunction blocking Kentucky and Tennessee from implementing these laws, was initially successful in getting that injunction. A divided panel of the Sixth Circuit by a 2-to-1 vote then reversed that injunction. And then the Solicitor General's office sought and obtained certiorari from that decision, reversing the injunction. And in particular, one of the interesting facets and things to watch out for is the parties' arguments about Bostock, which is the 2020 decision from the Supreme Court in Bostock versus Clayton County. In that case, the Supreme Court held in a divided by a divided vote that Title VII of the Civil Rights Act, when it prohibits discrimination on the basis of sex, that language covers discrimination on the basis of gender identity and sexual orientation. And of course, because that was the only issue before the court made clear that it was ruling on the statutory interpretation of Title VII, not on the scope of the Equal Protection Clause. But one of the things the parties here are really focused on is, how should the court's decision in Bostock really inform its decision in this case? The Sixth Circuit and the states basically say, look, that's a totally different question. Title VII is a statute. This is the Constitution. That they're worded differently. They don't use the same language, and you can't just take Bostock's holding and import it over here to the Equal Protection Clause. The United States and those on the other side take obviously the opposite view And I can read kind of the key passage from this was from the cert petition that the SG filed. But they say the Sixth Circuit did not explain why or how any difference in language between Title VII and the Equal Protection Clause requires different standards for determining whether a facial classification exists in the first instance, such that a restriction could simultaneously be sex-based under the former and yet sex-neutral under the latter. Bostock's core insight is that it is impossible to discriminate against a person for being transgender without discriminating against the individual based on their sex, because sex plays an unmistakable role when a person is penalized for traits or actions that would be tolerated in someone assigned the opposite sex at birth. And that reasoning is just as sound in the equal protection context. And so I think you're going to see this become sort of a key piece of this case as it goes forward at argument and the opinions. I think it's not too much of a stretch to say that, there are probably at least 3 votes from the Democratic appointed justices to take that same position as the Biden administration and say, look, the court has already held that it's impossible to discriminate against someone based on their being transgender without discriminating on the basis of sex. The court's precedents say that sex discrimination is prohibited under the Equal Protection Clause, and therefore, these laws are prohibited under the Equal Protection Clause. On the other side, I think there's, probably safely, at least if you think of the 3-3 court, there's 3 pretty ready votes on the other side to say, no, those 3 didn't vote in favor of Bostock anyway, but, to say, regardless of what the court held about the 7th Amendment, that doesn't apply under the Equal Protection Clause. And then, then as to the other 3, I don't think they're certainly not a monolith in this regard. Well, I guess I should say Justice Gorsuch is part of the other 3. He joined Bostock, so that makes it a little bit of an outlier there as well. But all that to say, my best guess is that the court will affirm the Sixth Circuit. I think they will ultimately say that regardless of what sex discrimination means under Title VII in terms of sexual orientation or gender identity, that doesn't automatically translate over to the Equal Protection Clause, and that there's no basis in the original public meaning of the Equal Protection Clause to, apply heightened scrutiny to laws that are, based on gender identity. But again, it'll be interesting to watch, for example, whether Justice Gorsuch himself, who cast a deciding vote in Bostock, whether he agrees with the SG that the same logic applies to the Equal Protection Clause, or whether even he would draw a distinction and say, no, that's how I interpreted Title VII, but I interpret the Equal Protection Clause differently.
Yeah, Katie, that was where I was going to go with this. Justice Gorsuch, of course, wrote Bostock, as John mentioned. The chief joined it, and if both of those justices vote in sort of the same direction in this case, we might not get an affirmance. So how do you think those 2 are going to approach this case?
I mean, I think John's probably right that you don't, for Gorsuch especially, this is not a one-to-one. I mean, I think Gorsuch is this, or considers himself to be this strict textualist, and I think that's a big part of why he reached that conclusion in Bostock. And I do think it's not a one-to-one here, although I wonder, I think maybe the conversation over Bostock is maybe somewhat overblown. I wonder if you even really need it. I mean, as I understand the SG's argument, it's kind of 2 parts. And first, and it's basically arguing that there are 2 reasons that this law should be subject to heightened scrutiny. One, that it just facially discriminates on the basis of sex, not because it has anything to do with gender orientation or transgender rights, but because it separates men who want to, live as men from men who want to transition, and then there are these separations based on sex, and that it treats men and women differently, without even really getting into the question of, gender orientation or sexual orientation on the basis of sex. I think there's kind of this preliminary argument they make that to me has merit when you look at the way that the court has looked at these questions over the past few decades. I mean, reading some of the materials for this case kept making me think of at least the way Justice Ginsburg would always think about these issues, and her opinion, especially in United States versus Virginia, the VMI case, where, it's about the Equal Protection Clause, is triggered when you are trying to impose, you're acting on the basis of sex based on kind of overbroad generalizations of what a man or a woman is or should be. And there's a lot of that in this law. I mean, it very expressly says that the purpose is to prevent minors from having disdain of their sex and to kind of adhere to their original sex. And there's a lot of this language in there that, to me, I think should trigger this heightened scrutiny under the Equal Protection Clause, even without this kind of Bostock interpretive question. That's my kind of current reading on it. I'll be curious to see how the SG comes back in their reply brief and how argument shakes out.
And Jonathan, the other thing I forgot to mention is that
we're running short on time.
Oh, sorry. I was just going to say,
go, John.
This is one of the cases where, a potential change in administration could also, radically shake up, if not just end the case. That, you imagine that a Trump administration might have different views about whether to continue pursuing this challenge to the state laws.
Yeah, well, that's something else to watch. Well, we've only got a few minutes left. Let's turn to at least cover one more case. Michael, you want to tell us a little bit about U.S. Nuclear Regulatory Commission v. Texas?
Sure. This is another grant coming out of the Long Conference. This case involves fundamentally a policy question about where to store spent nuclear fuel and whether it can be stored off-site, i.e. away from the nuclear reactor that generated the fuel. And this case involves an attempt to establish a storage site for such spent nuclear fuel in West Texas. And as a legal matter, it presents two questions. One's about administrative review procedure. The second's about the interpretation of two federal laws governing the nuclear energy industry. First, the Atomic Energy Act, and second, the Nuclear Waste Policy Act. So just brief background. A private company seeks a license from the Nuclear Regulatory Commission to establish an offsite storage location in West Texas. Texas doesn't intervene directly in the licensing proceeding. It could have, but it didn't. Rather, it submitted comment letters. It submitted a comment on the environmental impact statement, didn't intervene directly. Two other private coalitions of landowners, business owners in the West Texas area, they did seek to intervene, but they were denied leave by the commission to do so. After the Nuclear Regulatory Commission grants the license, Texas files a petition for review with the Fifth Circuit under the Hobbs Act, which allows, quote, a party aggrieved, unquote, by a final order of specified agencies, and the Nuclear Regulatory Commission is one of them, to seek review directly in a circuit court of appeal. The Fifth Circuit ruled in Texas's favor. It first held that Texas could challenge the license under the Hobbs Act, even though it hadn't directly intervened. And it found that it could do that under what it called an ultra vires exception to the Hobbs Act's typical requirements. It said, if you're arguing that the agency exceeded its power, acted ultra vires, then you don't have to qualify as an aggrieved party under the Hobbs Act in order to be able to lodge that type of challenge with the circuit court. And then second, as for the federal nuclear regulatory laws, the Fifth Circuit held that neither the Atomic Energy Act nor the Nuclear Waste Policy Act allowed for a license to be issued for off-site storage of spent nuclear fuel. And prominent in the Fifth Circuit's opinion was the fact that the Nuclear Waste Policy Act is really calling for a deep geologic reserve to be established as opposed to these types of off-site locations. So the Solicitor General sought review. It noted that the Fifth Circuit decision had created circuit splits both on the administrative issue and on the federal nuclear statutory issue. We don't have the merits briefs yet, so the battleground's not fully set. I think the court may struggle to accept the Fifth Circuit's ultra vires doctrine. It's not tethered to any language in the Hobbs Act. I thought the Solicitor General's brief did a good job of tracing back through the history of how that doctrine developed and pointing out that the first cases that talked about it predated the Hobbs Act's enactment. But I think there still may be a pathway to reaching the interpretive question about the federal nuclear regulatory laws, because there still is an argument that Texas participated sufficiently in the licensing proceedings to qualify as a party aggrieved, which is a point that Judge Edith Jones made in an opinion concurring in the denial of en banc rehearing in the Fifth Circuit. And if the Supreme Court does reach the merits, I think they may be receptive to Texas' arguments for narrowing the authority of the Nuclear Regulatory Commission in a hot-button issue like this one.
Thanks, Michael. I just asked one question, and we have to wrap up here. I'll point it to John. If they do get to the merits here, this is yet another case where the challengers are invoking this major questions doctrine. I wonder if the court is going to kind of run tired of this doctrine, and this sort of seems to be invoked in every case, or is this really another place where we're going to learn more about that doctrine and the limits it imposes on agency authority?
Yeah, so I mean, we'll have to see. I do think the court tends to enjoy announcing these standards and then pushing the work down of kind of fleshing them out. And not to say they'll never do it, but I think they're going to be eager to avoid that as much as possible and pick their battles as to where to weigh in. Not to say this couldn't be, but I'm not sure this is a case where they're going to be that.
All right, well, we've got to the top of the hour again, and I think we've run out of time to talk about some of the cases we had in the docket. I'll pull up a slide here as we finish. There's some interesting cases coming down the pike. I think you can keep an eye out for these. Likely to see them come out of the docket soon. Beyond that, thanks very much for joining us. Thanks for sticking with us to the end here. If you've got further questions about these cases or other doctrines coming up, we're pretty easy to find. Please reach out. And otherwise, we look forward to talking with you again soon.